construction law, CLE. I'm not sure how many out there actually practice construction law or do not, but today I decided, since I didn't really know who the audience was and how I would kind of change it up rather than bore everybody with a construction law and talking about the application of ICLE formulas to delay damages and all this other stuff, and have a boring CLE to try to give you guys something practical that you could take away. And that's basically applying construction contract law, which we'll see is a lot of the same terms that you will see in every one of your contracts that you deal with your client, or maybe even in the practice of law, and looking at some of those terms that are in a construction contract that are very similar that you may find in some of the contracts you see, and talking about that during the COVID-19 era, and talking about how we could review these contracts, modify these contracts as we see fit, or defend against these contracts. So with that, I will move along to a little bit about me. I've been practicing law solo for probably about 3 or 4, make it about 6 years. Originally, I graduated from Southern University Law Center in '98. I went to work for the federal courts for 2 consecutive terms under Parker and Tyson. And then I started my career, and the first place I landed was in a construction law firm, which I really had nothing and no knowledge about, but I soon learned to appreciate it and like it. As my career progressed, I went to work with another firm and learned business and employment law with that. From there, Katrina happened, and then the state of Louisiana contacted me and said, hey, would you be interested in coming and help us out with some of the Katrina rebuild? So I was there for 6 years working on various projects and everything, doing construction law, including some of the things that you see pictured. Here's various projects that I worked on in my career. After I left the state, I started my own practice and continued doing much of the same thing till one of my clients really started doing real well. And then I said, you know what, I'm going to even bill you guys to death, or we're going to work something out. And so they said, well, we're really growing and we need your help with operations. So I started there as a chief operations officer. And this year, in the midst of COVID, I decided, you know what, I'm ready to go back out into the world. And I restarted Bonaventure Law Firm, and I've also started this company called Next Level. Next Level, what it is basically a development management, construction management, and using me and some of my partners, but me more in alliance with my legal experience, trying to get from the point with our clients that we put together these great contracts for them. And we're like, man, this is solid. You guys are ready. And we send them off onto their way. And 2 or 3 years later, they come back to you, man, I got a problem. You're like, what exactly could have happened? And you figure out, you didn't follow this clause, this clause, this clause. So a lot of the people, they get their contracts and they run off and do them, and they never bother about looking at the terms, whereas the other side is looking at them. Some of these projects up here that I worked on in the past, either putting together construction contracts and putting together the documents for them, or actually doing part in the construction work, is the University Medical Center, with all the bells and whistles that came with that. This one over here is the Lafourche Parish Correction Center. Was one of the first public construction management at risk jobs that kind of went outside of the bid law legally. This one right here is Cameron LNG, where as the operations officer, we moved about 1,000,000 yards of dirt into this swamp area to build this plant. Over here is the water campus. I worked with the state after I left to do all the land negotiations and stuff. And the same with this. This is the Breck facility and the another facility that's owned over on Ardendale, and this is Golden Pass. And this is one development off of Hoosiatu. I've done several of those with residential type developments. So that's a little bit about me. I've been putting together these things forever, and so I decided, today, rather than bring you guys through that, I'd bring you through the COVID era and get you some knowledge on how you could improve your contracts for your clients. Even if you don't practice construction, there's going to be some nuggets that you could pull from this. So let's talk about basically start with the state of the construction industry right now. So I got the Joker up there. Is it just me or is it crazy out there? And that's about where we are, guys. I mean, times are everywhere. It's tough, but the construction industry, it's kind of like a canary. When it starts, you could watch it, and if jobs aren't going, jobs aren't being bid, jobs aren't being done, then soon to follow us even more. And to be quite honest with you, we've been seeing beginning of the year, everybody was on course, looking good. By mid-year, projects that were slated to start were canceled or delayed. Recent poll by some of the contractors in the state said by mid-year, about 3 out of every 10 of those contractors had jobs delayed or canceled. Well, that poll was done within the last couple of weeks, and now it's reporting by these guys that 6 out of every 10 contractors that we polled have had jobs delayed or canceled. So it's hitting everybody real hard. Competition's really begun to tighten because to make sure the lights are kept on, we are seeing bigger companies and bigger construction guys go after littler projects. The littler guys are kind of getting squeezed out. It's devastating on them because they don't have the ability to get it with all the technology and support the others have. And the guys that are going into these smaller ponds, they're finding lower margins. So it's really not paying them off. It's really keeping those lights on. And it's not just a matter of the economic effect on these projects. Projects have also been halted because of COVID outbreaks, quarantine issues. Absenteeism has grown as people have to tend to family or stay quarantined, take their kids to school for daycares and everything else. And then there's costs that have been escalated throughout the industry because when the manufacturer has to quarantine in place, you don't get that air conditioning unit that you were looking to have delivered to the job site. So those are some of the issues that we're seeing in construction. You simply could take those issues and, apply those to the current situation that you may be dealing with, and you're saying, hey, the industry or the people I'm working with or my clients are having some of the same problems. So before I get too deep, as I said, I don't really know who's out there and what, but I decided, let me just give you a little bit about construction law because, and saying, hey, is that really some type of different animal than regular contracts? If you ever taken one of these cases, you may have had a regular defect case or something like that. But it's also very possible when you get into one of these cases, it becomes complex. So construction law is basically a combination of many different legal fields. it's not a specific singular subject like personal injury law maybe or something, but it's a combination of law, finance, real estate, bankruptcy, administrative, employment, environmental, insurance, regulatory, all these different things that you stay on top of. So your client who is out there tossing dirt around or hammering in a nail is not really keen and aware of them. So he's depending upon you to stay in the know on all those. And it gets complex because it gets intertwined with a bunch of other fields: engineering, architecture, accounting, and just a few of those. And it also comes with its own terms too, so that could actually throw you off. And you're not necessarily dealing with one party. Many times you're dealing with several different people with several different cause of actions, everywhere from, you have your owners, engineers, architects, environmentalists, contractors, subcontractors, material suppliers, manufacturers, bonding companies, insurers, bankers, etc. All those guys. So it leads to some very document intense and some complex cases sometimes. But the non-complex piece is that basically, when you really look at it from afar, it's contract law, because everything revolves around what parties agree to. There may be several different contracts in the mix, but it's all about what the parties agree to. So with the little briefing on construction law, I'm going to take everybody back to that first day of law school at Southern University and that first contract class, and just go through a briefing of those, and then just to refresh you, so when we go through these things, you can see how it all plays out. But knowing what the contract says and being able to draft, review, and interpret it is very important, because like I said, your clients are depending upon you. You're not necessarily, you would think that, hey, they're educated on the terms of their contracts and everything, but many times they put it aside and say, let's progress to work. And we're not just talking about the contractors or subcontractors. This includes sophisticated owners, sophisticated engineers, sophisticated architects. I've represented them all. They have a tendency just to put the contract aside, which it probably happens in numerous different industries as well. I'm certain, and I've seen actually. But plans and specifications, which makes it a little bit different than others. Plans and specifications are usually included in those contracts, but the core governing document is what's referred to in some contracts as the terms and conditions, or you may see them referred to as general conditions. And the general conditions, usually those are set out if a standard form is used. The American Institute of Architects has the real go-to standard form that people use for contracts. Their copyright says do not reproduce it, do not change anything in it. So you will see another set of conditions called special conditions with those that just either basically they're saying scratch this, add this, and changing those clauses without modifying the general conditions for particular projects. The terms used in these documents are maybe familiar, but it all boils down to contract interpretation. And it's the law of the parties. As always, the contract is there, and that becomes the law of the parties. The people don't realize it, and they sit there and go out and say, well, I didn't know that, I didn't know that. And as many of you know, you point back and say, well, it's in your contract. And so the reasonable intent of the parties to the contract is sought by examining the words. When the words of the contract are clear and explicit and lead to no absurd consequences, you really have no further interpretation. The common intent is in accordance with the general ordinary planning, popular meaning of the words used in the contract, and pretty much it's given the industry standard use of it. So, which can be still tricky because there's many different terms, like I just went with, just terms and conditions, general conditions, special conditions, that it could be tricky just with those terms to say exactly what you're looking for and what you need, which brings up the first part of what I'd like to start with contract documents, and in particular construction contract documents, but is the definitions page. So some of your larger construction contracts, as well as others in other industries, you'll see contracts starting with, here's a long list of definitions. And really that's great because it serves 2 points. You don't have to define them over and over in the document, and the parties are really very clear on what you're referring to when you use a term, and that's what you're out to get, especially when you're dealing with COVID-19. So, for example, when you say something like the project, well, it could mean several different things, and we could all put our own meaning on it. But when you define it with a clear reference to the project located at 123 Main Street, that's more specifically defined in attachment A's legal description attached here to and made here part hereof, you're pretty much defining it and saying this is exactly what I'm referring to. So when we start addressing COVID-19, we want to be precise as well as to these terms we're using in the contract. So whether you're drafting it or reviewing it, these terms that are out there, they're not in any contract because we never really had this experience with COVID-19. So the first definition that you would like to add to your contract is COVID-19 itself. So you don't have to repeat what we are talking about or anything else, or whether it's a variance or a different strain or anything. This is just a sample definition. You play with it as you feel, which, by the way, I'll get you guys these slides with the notes on it, and I also have it attached on my website at bonaventurelaw.com in the news and publications section. I just put it on there before here. So if you want to refer to any of this stuff, it'll be there on the website as well. Another definition that you want to add is your COVID-19 proclamations definition. You want to define this term in such a way that you collect all of the orders, directives, and guidances. You don't want to get caught and refer to the original proclamation, which has been amended. You also want to make sure that you're gathering up the different ones and saying, okay, I'm not just going to refer to the governor's executive orders. There may be others to this particular industry or this client or this owner that you're dealing with that has their own set of proclamations. Contractors Licensing Board, DEQ, DHH, DOTD, each one of them may have their own set of guidelines. So you want to be able to encompass all of those into one when you're defining that term to capture them all. A third term you want to try to define, and this one is probably the trickiest when you're rewriting this for the new era of COVID contracts, is the COVID-19 condition. And what I mean by that is to give you a little bit more on construction contracts. Everything in a construction contract revolves around who has control, who has the responsibility. We'll talk more about in fortuitous events, but with fortuitous events, it's, hey, who had the control of this specific thing at the time, and who bears the responsibility. So if you're drafting or revising language, you want to make sure that when you define this as something, you could define this like as something attributable to COVID-19 not caused by your client and beyond its control. So you want to make sure that you're saying, hey, this is not within his control and he had nothing to do to control this situation. Be specific in the definition. You should list the specific items out, such as the COVID proclamations and supply, as they relate to supply chain distribution due to COVID-19, or whatever your client's contract is. You want to sit there and make sure that you're specific as where this is not going to apply. This will be beyond its control because they can't handle if the air conditioner manufacturer shuts down because they have a pandemic. It shouldn't be on their back when you cannot get air conditioners because of COVID-19. So you want to be specific, but at the same time, make sure you put into this definition a general catch-all on COVID-19, such as other circumstances concerning COVID-19 not caused by the contractor and beyond its control. So you can make sure that at least you're trying to cover it with a catch-all. You may not be able to extend that all the way out to just anything, but at least you're capturing that provision. So that's about three most important definitions. You may find more and you may know more that you're putting in there. Please share them with me. I'd love to hear them, but pretty much that's what we're doing and seeing in the construction industry on putting those out. The next thing and the next subject on COVID contracts and whether they apply to construction or normal business and other industries is a clause that discusses compliance with the COVID-19 proclamations. It doesn't matter, what type of industry or what their beliefs are and whether they believe COVID is a hoax and COVID is not real. You to protect yourself, you want to put it out there to your client that you really need to at least have this clause in there that compliance is required. They may say, oh, I don't want it, but at least you covered yourself on telling them that there should be a clause in the contract for it, because if something does happen, if something does break out, at least that they have that in writing and governing the compliance and not just sitting there and saying, no, I didn't want that in the contract. And so you're protected. So definitely think about putting in there that the parties will comply with COVID-19 proclamations to the best of their benefit, and that becomes the law of the party as well. So that protects you and your client. Okay, in many contracts, you will see this clause, time is of the essence. And so in construction contracts, it's definitely written across the pages because time is definitely money in the contractor's world. If you don't get things done timely, the contracts also say for the contractor, here's some consequences, everything from termination, demand on the surety, if you have a bond, and surety bonds are for the contractors really no joke, because the bonding company requires them to basically put up their personal property to guarantee that bond. So this is not just a walk away to bankruptcy court. If their bonding company goes and completes that job, their personal property could be on the line as well. There's when a completion contractor comes in there, there's the charges that the owner will do to hire mitigate damages because you were not on the site, including hiring a completion contractor with the back charge. And at that point, the owner is ready to get his job done. He's not looking to sit back and say, okay, well, let me go and bid this thing to find the cheapest and everything. He's already tried that. He's going to put in someone to finish and complete the job. And most contracts in construction have a back charge provision where they will be charged back for the difference. And then there's liquidated damages. This has become pretty standard in all construction contracts, and there are quite a few of them throughout other contracts as well. But the parties stipulate to their damages, say this isn't punitive whatsoever. And usually it is a pretty fair representation of what the obligee would suffer if he'd actually be exposed to a day of delay damages when you calculate all the costs and everything that's involved. So those become pretty hard to get past when you're delayed on the job. And when you're dealing with a COVID-19 situation, the numerous things that could pop up, delay can actually happen. So when we're talking about delay, there's two types, or there's two ways that in Louisiana we deal with delay. Other states have what's called frustration and impracticability and stuff. And we have Civil Code 1873 to 1878 that talks about impossibility of performance. Now, this is a default rule. It's only if you do not have some type of delay force majeure language in your contract already. If you have some type of force majeure delay contract provision in there, the courts are going to find, hey, the law of the contract governs. But this default rule is really tricky and really hard because it requires that you prove that there's not only a fortuitous event, but it was unforeseeable, which both of those are pretty much part of a force majeure, but it also has to render the performance by the party impossible. So, and that's where the standard and the bar really gets high, is to prove the impossibility of performance. So the main provision and what you want to do anyway is to, if they're not already in the contracts, is to go ahead and put some delay clauses, no matter what, whether it's to cover you as the owner obligee or however it's listed in your contract, or whether it's to cover the obligor, contractor, or whoever else is contracting with them. You want to have some type of thing to address delays. If not, when the delays come, it can be a mess for the court to try to figure out all the different types of damages and all the different types of causes of delays, especially in a construction type job when you have 5 or 6 trades going on at the same time, and one had delayed one day, one delayed another day, and you're trying to sparse all this out. But the first thing you want to do in delay clauses is, or anything with your contract, as when you're looking for it for delay clauses, is go back to that unlooked at provision with the choice of law and what law is going to govern the contract. If you're dealing with the construction world, you may very well be sitting there taking a job in the state of Louisiana, sitting there saying, hey, I'm doing this on Louisiana soil and I'm going forth with it. But you'll see that the choice of law that governs is from another state, and the contractor put it in there. And I know this is done throughout the industry, especially in commercial contracts as well. So look at the choice of law and then go to the delay clauses. So some of the delay clauses that you may see, specifically in a construction contract, but also in other contracts, is if they do not have this provision in there, a lot of construction contracts didn't. It's becoming more popular today now with COVID-19. It's a change in law provision. And basically it's setting forth if the law changes that affects the contract, and the way that it would affect the contract will change with the law, rather than you're sitting there without any relief. The law's changed, and now it's caused you delay damages. So look for that. You may want to add that in. Another one is the force majeure. That's the go-to provision of COVID right now that everyone in the contract world is talking about, looking at, and it's very important. We'll go through that one and these last three in detail too. One's the owner direct suspension, when the owner says, hey, I'm going to suspend the contract. Another is when the owner says, you know what, I'm going to terminate it, but I'm going to terminate it for convenience. And the other one is termination for cause. If you just sit there and walk off this contract and abandon it, even though it's COVID, and you don't follow your notice provisions and everything else that are sitting there in the contract that you need to follow, the other side may sit there and say you've abandoned the contract, and then it falls right under that termination for cause provision. So we'll talk a little bit about notice more in a few minutes, but remember, in construction contracts, as we start this delay discussion, construction contracts, the two things as far as delay is concerned is, one, as we already talked about, responsibility and who is responsible and who's in control. And the other one is foreseeability. And that's a big part of the delay clauses, is whether it's foreseeable. So the first one that we'll talk about is the main one, is the force majeure contract clause. And a force majeure is a clause designed to excuse a party from performance of its obligations under the contract upon the occurrence of certain specific events are beyond the party's reasonable control. You often hear it referred to as an act of God. Classic example, Louisiana, we've used these a lot more than other states that are now sitting there and polishing them off for COVID, because this is one of our provisions that comes up every hurricane season, and probably some of you guys in Lake Charles are looking at that and using that right now with all that you went through this year. So that's going to be your go-to clause. So you want to look for the contract through the contract, see if you see it may not use the word force majeure. It just may be you just have to look through the wording in the contract to see whether you have anything that's talking about something that is a fortuitous event beyond the party's control. So to give you an example of how this foreseeability and all plays out and has played out in the construction world, and it's really, where this question comes from, does being aware of COVID-19 make it foreseeable? Well, contractors, when all the delay and everything associated with COVID started, contractors were concerned that anything COVID related, it was going to be deemed foreseeable, because, hey, the contractor would sit there and say, hey, the owner would sit there and say, hey, you know what COVID is. You knew that was a problem. It was foreseeable. You didn't take precautions. You didn't add it in your bid price. You don't get more money for it. So that foreseeability pops up there to make sure that, that you describe it, and it's in such a way that it's beyond something that you could have envisioned. And so when you're defining that COVID condition, that's what you're looking for, and that's what you're trying to express, something that, hey, I couldn't have helped, and I didn't see it coming to prepare. If they're foreseeable, then the contractor may not have a defense against some of the delay provisions, plain and simple. Specificity as to what the COVID-19 conditions and when does that COVID-19 condition become foreseeable is important. So what are you going to look for when you're looking at this provision? You found it in the contract, now what? So what you want to do is identify the obligation that's involved, identify the event, identify the impact, and identify the remedy. So let's break that around. When you're applying these force majeure provisions, you want to specify the identity of the obligation that's actually involved, the event that, so you want to talk about the scope and the wording of the first force majeure clause. That's going to determine whether the COVID-19 pandemic fell within the scope. So when you're looking at what the obligation is, you're looking at, hey, who has control over this? Who has the actual obligation, and whether it fell within your client's scope. The force majeure clause may refer specifically and to a pandemic, and so you want to put in there, when you're defining it, a lot of clauses simply do not have that catch-all. They define a set group of terms. It may have hurricane. Some of them say it has to be named hurricanes. You'll see those in insurances, and all kinds of different ways, and it doesn't have a catch-all. So regardless, you want to use those specific words, pandemic, for example, act of government which has prevented contractual performance, is a definition that you could use for pandemic. You want to relate them all back. A party, if you're seeking to rely on that force majeure clause, you need to carefully consider whether a pandemic constitutes a force majeure event, because you don't want to sit there and have it where, okay, I'm going to use it this day for a event, and I don't want it used the next day because he's going to use it the next day. So careful wording and carefully being very specific about what you want to protect your client from in drafting of these things is important. Another thing, you want to identify that type of event. You want to say pandemic, government shutdowns, whatever it is that you foresee. This, even though it's foreseeability, but whatever that could cause something, you want to sit there and say, hey, it's a government shutdown, and this is where defining that term and the government's proclamation will come in handy. So once you have those things defined, you're looking at a triggering event that you also need to be clear about when you're writing this force majeure. It'll be necessary for a party to seeking to rely upon a force majeure to demonstrate that COVID-19 pandemic has actually caused its failure to perform its contractual obligation. So you're not going to just get away with saying, hey, it's all because of COVID. You're still going to have to show that, okay, well, that situation, that this triggering event is what will trigger this force majeure clause. So, and a lot of that's going to depend. You could write it the best way you can, but your clients will come up with a way to beat any facts that you go over in your head and find a way to make it where, well, that I never even thought of that one. So the mere fact that a contract becomes more expensive too, this is one of the things that people sit there and say, man, I want to get out of it because this contract's now just too expensive because everything's been went up in cost. That's not usually enough by itself for you to be excused from your obligation. And remember about the foreseeability and the timing of it too. So if something becomes foreseeable before you bid on it, then in construction parlance, the owner or the general contractor, whoever you're contracting with, is going to sit there and say, that was foreseeable at the time you bid, and so you should have included that in your price. So timing is important because it may affect what you could recover on a delay payment. And then you want to identify the impact. Has it caused a failure to perform? More expensive is usually insufficient again, but a clause that may assist you if you're looking for a clause to, do something when the prices go up is, I'm not going to cover it in this brief, in this session a lot, but you can add in an escalation clause. And you can do this in any type of contract. So when that air conditioner, when that HVAC plant shuts down in Chicago and you can't get the parts to finish up the air conditioning system, and that plant shuts you down and it delays the job, you want to know, depending upon how and who you're drafting for, whether it's included and what the parties are intending to include and not include in this contract document. So it's a clause that can be quite strenuous if you want it to put together, but it can be kind of loose too. And again, we know that that's going to be up to the courts to discern. As I said, AIA is pretty much the standard language, contract language in the contract that lots of people use. So with an AIA document, if the contract is delayed at any time, you see this language here is not that specific. It doesn't have a lot to it, but again, if there's something that you need to add to make sure you have that specificity, this is the way you'd add it. Of course, with AIA, you'd add it in another document, but you would add this in. If you're reading this and reviewing for somebody, you want to make sure that you, even though you see the little seals all over it and saying it's an AIA document and there's no special conditions, read this anyway, because a lot of people will go ahead and get on their Adobe and modify the document as they see fit. So they may have changed a language. Another thing about the language, and when you're putting in words such as pandemic, government shutdown, be careful with the word that was previously used and it's coming under fire in courts, and testing it, whether it applies to COVID, is epidemic as opposed to pandemic or outbreak of disease. So you may want to include all three, but again, an epidemic and pandemic are technically not the same thing. So there is argument out there to that. So the other thing is, without that catch-all clause, if your contract limits force majeure, in that case, you're going to be in a situation where courts will be less likely to find that the parties intended to cover the pandemic. Unfortunately, pre-COVID days, this is where a lot of contracts are. Now, as we look at this thing and as it drags out and we start to question how much more and how longer and what next, it may be a good idea to cover it. So the relief that you could put into a contract that would be available under force majeure, if it's a valid force majeure, The party relying on it may have a clause in there for compensation for work performed and to maintain the site during any suspension or shutdown or anything else. If you're the contractor or the contractor's your client, and you're looking at this clause, you want to make sure that's covered in, because even though it could be an AIA document and some of the other documents, they will take it out, the owners, and leave it just as a time extension only. So you get time, but no compensation for anything to maintain the project. You can see a temporary suspension of all the contractual obligations with only the extension of time, like I just said. You're excused from your contractual obligations without incurring any liability. So if this project shuts down and everything else, well, now you're excused from any liability for it. So because this force majeure, you weren't able to complete, you weren't able to perform fully. So those clauses usually will excuse you from those obligations. So if you were doing a horrible job building the building to begin with, you may have lucked out if the contract gets terminated for that. Another thing you want to look for and put in there is sometimes there will be an indefinite time on force majeure. Sometimes people will specify that the force majeure has to continue for a certain period of time before it cuts in. Well, make sure that you put into that contract that if it continues for a certain period of time, that you have to stay on the job site. We go back to that compensation before COVID kicks in, that you want to be paid. In the construction world, that's a big deal, because when your equipment is sitting out there, when your manpower is delayed and you're still paying all these things, and there's no period of time, or the period of time commences sometime in the future, then you're not getting paid, and your stuff still has notes, and your employees still have payroll. So one thing that has arisen lately in construction contracts, and from the owner's perspective, they're great. From a general contractor's perspective, they're great. Subcontractors, vendors, and everybody else that are lower tiered, they hate them, but they're usually, forced to get into them or not get the contract. And those are called no damage for delay clauses, where the contract will sit in there and it'll say that there is no damage for delay, and you will not get anything. So be sure that that clause, if it's in there and you're looking for a subcontractor or a vendor or any other thing in your industry, and you see a no damage for delay clause, go ahead and get your red ink out and see whether you can get rid of that. So there's other documents besides the AIA. The AIA is by the architects. The Engineers Association, they have their own called consensus doc. It specifically references the contractor's right to an equitable adjustment price for costs and delay. The federal government's contracts provide a contractor's entitled to compensation for increased costs for suspension. So you may have some that are automatically in there. You may have some that are not. So it's important to read everything in your contract. So another part that can trip you up in a force majeure contract is both mitigation and notification. So you have to give the other party, usually it's written in there, a notice that the force majeure condition has arrived. And so when that notification comes up, I'll give you an example. Supply of goods contract may require a finding that alternative method of transportation for goods is desired when one becomes unavailable. So if you don't give them notice and there's another way of doing this and you haven't, and you can't even mitigate it, or neither can they, then it's going to, court's going to be really unwilling to enforce that. So you need to make sure that your client knows of these provisions and are following them as soon as they happen. So with the notification, you see everything shut down, stay-at-home orders, slowdowns in the supply chain, labor begins to get affected by bonded projects. It's important to keep in mind that just because it might be shut down doesn't mean that the deadlines are not applicable. Those deadlines keep going on. So unless you stopped it to say, hey, the schedule stops, without notice, they continue to run. So you want to stop that, and it's critical to also to determine it, because when you do that, you know, not only are you with a notice of claims where you're putting the contractor on notice that, hey, I got a force majeure situation, so you can't really go after me on claims, but it also affects lien rights, delays and impacts, several different parts of the project. So complying with notice is extremely important, as well as the documentation of it. As soon as you go on to that notice, you want to get with your client, and this is where you sit there and say, okay, I'm going to have to step out of my attorney role, but really to protect you, I'm going to counsel you and tell you that you need to get in there and document everything as soon as you put that other party on notice. You want to show, hey, this is how many masks that I had to buy, and this is how many wash stations had to be rented because of this proclamation. This is where I had to affect my schedule because of social distancing and all these different things. This is where my cost have went up because of safety. This is where my cost have escalated because of material prices. Document. And then there's mitigation. Even if a force majeure does not expressly include an obligation to mitigate, you still want to advise your client that, hey, you need to mitigate this thing if you can. So let's say we have a force majeure situation, the contract suspended, the equipment's all sitting out there and everything. And during that time, you know, hey, claims and everything is not running. So your contractor is saying, hey, I'm off the hook. Well, no, he's not off the hook. Your contractor needs to sit there and say, look, during this time, during this period, is there something that can I be using this equipment elsewhere? If they show and you come back and say, look, I had to rent equipment and this and that, and it's like, well, you could have used your other equipment that was on site. Why didn't you use that? Then you have to show why you didn't use that to mitigate. Now, one defense to that always is, well, when I do move my equipment off site, that's going to be an added cost that you'd have to pay for. And then to remobilize back on the site is another piece. So the bottom line is putting it all together. And, you know, it's not just to protect you on your claim. You're also keeping records of all this. You know, you don't want to be accused of a spoliation of documents. With these projects shut down, a lot of times what happens is there's nobody in and out the sites anymore, so theft occurs. So documenting, showing what you have, what's lost and everything is extremely, extremely important from not only a damages in a delay claim, but from a risk standpoint as well. So the next thing, let's move away from the force majeure, and very similar as part of delay action, that it's not just a standard delay clause, but this is a provision that kind of gives the owner or the general contractor, whoever the obligor is, a way to terminate and or what he can do under that force majeure clause. He could suspend the work, or some contractors have and owners have in their documents a termination for convenience clause. Rather, like in this COVID situation, what we're dealing with is, rather than deal with the cost of an ongoing project delays caused by COVID, the owners are just saying, hey, we'll suspend the work and till such times pass. In other cases, they just really don't have any choice because of what's involved, and the government saying, no, we can't, we don't want you doing this type of work right now. So particularly like in those contractors or those people that are dealing with the hospitality industry, they're at the mercy. If you had a couple good restaurants that you were building or renovating as a contractor, you're suffering right along with those people. So the owner, when the owner may want to suspend the work at the project due to COVID-19 health concerns, even though the contractor is allowed to proceed under that proclamation. So this is where, this is going to happen on a termination or type where the building is partially occupied or something like that. It's like, look, I'm going to have to suspend it because I got my people still in here, and the social distancing and everything else, even though you're allowed to continue the work, I can't have so many people in and out and coming in without being able to check on them based upon the proclamation. So if the contractor provides the owner's right to suspend the work for convenience, then one thing that you could do is add language that describes what type of suspension it will be and states when it will be a suspension. Because those same things that are talked about is notice and telling you that, hey, this is falling under the force majeure, the obligor is responsible to tell you those as well. So if the contract doesn't allow the owner to suspend the work for reasons other than the contractor's breach, you might also want to add a new section that specifically addresses that and add that in so the parties are clear. So some drafting and review tips for suspension. One of the things, there's different types of suspension. Like we went over, you have the suspension where you're partially suspended, you're fully suspended. Well, you need to know in drafting what's going to be those triggers of the suspension and how are they going to be paid. If you have a partial suspension, what work is going to constitute actual work for you to continue to be making time and schedule. A lot of times you'll see the guys go out to the job site, maintaining their equipment, doing certain things to maintain the job site, but not actually progressing the work. And the owner comes back and says, I'm not going to pay you for these days because you were on the job site working. And it's not my fault you didn't do anything. And they were just not allowed to work. So you really need to clarify what's going to cover it. And adding that new section to deal with COVID-19 health concerns. So you have health concerns, your client has health concerns, then there needs to be some type of way to address it if they're hypersensitive to it and COVID and are like, hey, I'm going to, interpret further than the proclamations. They have every right to do so, but they need to make sure that the contractor and them are on the same page. Again, this goes back to our basic meeting of the minds when putting these sections in, and then it gets to the real hard part on saying, okay, let's interpret these contracts that no one drafted with the idea that 2020 would bring what it did. So here's another AIA document that shows some typical suspension for convenience language. Other contracts take a variety of forms, and it may contain language that the contractor only receives a price adjustment if work is suspended for more than the stated duration. So you may also see them that allow one or both parties the option to terminate the contract if suspension lasts beyond the stated duration. Representing the contractors, I always like to put that in there because the owner is quick to say I could terminate for convenience, but the contractor needs to sit back and say, look, I'm not quitting on you, but call me back after this is done. I need to go ahead and move on and not be held in suspense while this thing is suspended. And then you have those that say, in some contracts, and we'll talk about this a little bit more later, the termination of the contract governs their right for compensation for work not performed and anticipated profits. So, but a lot of contracts nowadays will say, hey, there is a no consequential damages, and so no lost profits provision within them. But some of the private contracts may not include that clause, and there may be a sense of, look, you suspended me, you terminated me, I put my whole payroll on this contract and we're doing this as a job, and there's cases to sustain out there that says I'm entitled to my lost profit. So make sure you read to see whether there's a consequential damage clause. Usually they're mutual, so they work both ways. So realize that if the contractor gets involved and he's the delay, then the owner can use that to get his lost profits. And if they're doing something for a very sophisticated building or owner and it's very expensive to lose profits, then I had one with a casino in Marksville back in, it's been forever, but the lost profits on that case, without that clause in there, was considerable. And then one other thing when you're typing all these clauses, especially if you're dealing with this in construction or anything involving a subcontract, sub-vendor, sub-consultant type relationship that you're doing, and you'll hire someone else or your client hires someone else, make sure that there's a trickle down language that sends that down to the terms in this contract apply to those lower tier subcontractors. Because if you have a lost profits or you have a non-consequential damages clause in your contract and the other side and the subcontractors don't, and you don't want to be in a position where you don't get any consequential damages, but the subcontractor, you owe them. Okay, moving a little bit away from the actual delay clauses themselves that you'll find in a contract and that deal with COVID, talk about insurance coverages and everything on the contract. One of the main provisions and one of them that's out there right now is your business interruption loss coverages. You want to look at their policies when they come in with some interruption and make sure there isn't any coverage. Obviously, COVID-19 shutdowns, quarantines, decontamination areas, you're experiencing loss of business and interruption when this has happened. The problem is that these types of insurance, and it's written on a property loss type policy. So you have to actually show physical loss or damage to trigger the coverage in many of these. There's been recent cases, not anything in particular in Louisiana that's been out there, but there was one that I saw in the Pennsylvania Supreme Court that, Pennsylvania sat there and says COVID-19 pandemic qualifies as a natural disaster, and under the Pennsylvania Emergency Code, it triggered the business interruption loss claims. And so some of the people that have that type of insurance in Pennsylvania are able to rely upon the courts there. States have tried to do some retroactive legislation to make sure this business interruption coverage covers the businesses and everything. Louisiana had a law or a bill this year up, but the legislature pulled that. So that didn't go anywhere as far as a insurance provision. But we also have like cases that we could look back to across the country where you got mold, fumes, contamination, and everything else that constituted physical damage. So there's a lot of cases out there on this property loss, and it's very fact intensive. So really you need to examine the policies of your clients when they come in, look and see whether any of the facts can fit, and make sure that there's no coverage under it. Because sometimes there may very well be some type of coverage hidden, and then keep abreast of this, because I'm sure we haven't seen the last of claims against insurances for COVID losses. This one I talked about a few minutes ago was the mutual waiver of consequential damages. As I said, most contracts, especially in the construction world, have this provision. So if it's included in the contract you wrote, realize that those lost profits may not be something that can be collected when you're dealing with a force majeure type claim. Now, that doesn't mean you should not be paid for the work you're done, the work that you're doing on site, the delay time that it's taking and everything, but this consequential damages clause can affect you one way or another. And it's very hard to recommend to take it out, because if you take it out for your client, realize that the other side's going to say, well, take it out for me too. So it could be a considerable hit on your client if that's not in there. Another thing found in just about every contract these days, Louisiana contractors do have some type of protection against indemnity in the statute, but it just depends on what you're dealing with, a contractor, vendor, or anything else. You need to look at that indemnity clause and whether it requires one party to compensate or mutual compensation or whatever, but compensates for the losses of, lost profits and everything else with that business interruption loss would call for. A lot of the indemnity clauses, the general contractor will say, hey, if I don't care whether the air conditioner all manufacturers out of parts and you can't get them, I'm getting sued. This is what I'm being sued, and you are going to indemnify me for that. So read those provisions carefully and do what you can do best. But I found them hard to negotiate with the other side, especially if you're not on the bargaining end of the one that's drafting it and the obligor paying it. They're pretty strict. In Louisiana, like I said, they can't pin, and a lot of contractors, general contractors, were doing this, and they changed the law a while back where the contractor was pinning damages and indemnification onto the subcontractor regardless of the subcontractor's fault. So those provisions aren't allowed in Louisiana anymore. So also, before we move off of this slide, the limitation on liability. So this can also, you could also find this in some contracts, some they may not be. Maybe something that you recommend putting in, weighing your options. But to the extent that you could try to put it to a maximum dollar amount for which you or your client will be exposed, preferably within the amount that the insurance covers, is a wise choice, especially if some of these contracts, as your construction clients move up to the next level and take on bigger contracts. With it comes higher insurance premiums, and what you want to do is make sure that when they're paying for the insurance, it's going to good use, and that will limit their liability. So look for those clauses to protect your client. If not, discuss with them putting them in there. Okay, and this next clause in a contract is a owner's duty to provide adequate assurance of financing. So I've seen these clauses, and I've inserted these clauses into a few contracts I drafted when I was kind of, hey, this guy's kind of shady. I'm not really sure whether he will be able to make it through the whole contract or not. So what I do, you can ensure that they have adequate financing, saying, look, I'll take this job, but at any time, I want to be able to know whether financing is in place, and you're going to have to provide the document to show that financing is still there. During these times, it's almost a must. A lot of people didn't want to put them in there. It's like, man, I don't want to offend the guy that's paying me and anything else like that. And nowadays they're like, hey, I don't care about offending him. I need to know whether I'm going to get paid rather than drag my crew out for another month and I'm still looking like this guy with his empty wallet. Another clause, and I don't mention it in here, but that you'll find in construction contracts that are popping up, not really necessarily in a lot of the other industries that I've represented, but it's called a pay if paid clause. And what this clause does, it allows the general contractor to say, the owner hasn't paid me, so Mr. Sub, Mr. Vendor, you signed my contract that says I don't have to pay you unless I'm paid. There's plenty of case law that, you know, tries to protect the subcontractor as much as they can on it. And it's a very tough road, but the general contractors have been pretty persistent about putting that in there. And, you know, it would be fine and dandy if your general contractor would say, you know, we could do that. But when the general contractor sits back and says, man, I just don't want to go after my client, the owner. I'm good. I got enough money. It's not hurting me. I know he'll be good for it later on, and doesn't persist on collecting the money from the owner, and the subcontractor sitting out there stretching things and not getting paid. So be careful of these clauses if you're representing a contractor or a vendor, and try to take them out if you can. Okay, so after you get all this stuff together, you know, with your COVID stuff, the idea is like, man, how to build a contract. Well, you could do it two ways. You could put them, you know, as sentences with every provision in the contract that they fall under, delay, termination clauses, and everything else. Or you could go ahead and add a new article that is your COVID-19 article. So when you add that COVID-19 article, that's kind of like preferred. It keeps it nice and neat. So you could refer to everything as at once. And it's easier to comprehend. But from a drafting and a negotiation perspective, it's also kind of an efficient way to add in all that new language and article and pass and draft back and forth between the parties, especially if you're in the middle of amending the contract to say we need to do something about COVID conditions on a longer term contract, and both parties agree that there's a need for amendment, then it may be easier just to keep it there. So the last piece that I want to talk about is the compensation, and you know, all those pretty clauses that you add in and everything. They're great, but if your client can't get paid for it, it really doesn't mean a hill of beans. And again, some people drafting it for the obligor will have it for time only and no compensation. But I think it's important to try to breach that subject because of all these things that's involved, and what's involved with the contractor. Cleaning of offices and job sites, hand washing facilities, additional staffing, new safety guidelines, temperature checks, cramped office trailers where now you have to rent a tent or something to move outside. You know, you go to any construction site, you have the little bitty small trailer where 1,000 men and women are sitting in there doing work. Well, you know, that's unacceptable, and may not go with the proclamations that you're putting in with your definition. And so you need to address that. Absenteeism and delay, that's slowing the job down to try to get qualified workers in. The price escalation, materials and low-tier subs are becoming more expensive as the manufacturing chain slows down. So all these things are costly. And, you know, while all this is going on, you need to make sure that if there's a shutdown, a slowdown, closure of ports, whatever it is, that your client is protected and can weather that storm. So how do you go about doing that? So one of the things that you need to do, the first thing you need to do is identify the criteria for compensation. For example, the cost must be solely attributable. Does the cost have to be solely attributable to an unknown COVID-19 condition. So is this one of the, by unknown, unforeseeable COVID-19 condition? So is, depending upon how you draft it, what is the cost? And most people will agree on that, hey, it's solely for something that's unforeseeable and not foreseeable. And drafted to be, it's got to be reasonable under the circumstances. Don't try to make a jillion bucks off of it because you're not going to get anywhere in negotiation. Not be the result of the contractor's failure to comply with the contract documents or COVID-19 proclamation. It's not a result of the subcontractor or supplier's failure to comply with the COVID-19 proclamation. You can refer to a cost that satisfies those criteria as those unforeseeable COVID-19 conditions. You want to state the owner will reimburse the contractor for costs attributable to COVID-19 and which are not included in the schedule of values, which is basically the price. So, you know, these extra gloves, these temperature gauges, you want to say, hey, all these costs associated with these unknown conditions, this is part of what I'm going to seek compensation for. Again, be careful, and you need to look, and because or if you're on the other side to look at it, that you know that there's a fair balance between the two. And if the contract is, if you already knew at the time you bid and the owner could show that, or the contractor, the obligor could show that, then they're going to have a hard time to say, hey, let's add this in or to pay you for it. So another thing is contingency contracts. In some construction contracts and in other types of contracts, there's this contingency where that money's there for a contingent situation. You need to define under that contingency contract whether this money will come out of the COVID-19, if you have a COVID-19 incident, whether it'll come out of there or it'll come from some other pool. You don't want to eat up on your contingency, because the reason you put those in there is because you knew there would be unknowns in the contract to begin with. So I think I made it right on time to the 4 o'clock. So I'm trying to.
All right, thank you. We do have another session that starts at 4. So
okay.
If anyone has any questions, feel free to email Attorney Bonaventure. Also, the PowerPoint slide is on your website, correct?
Yes, ma'am. So you could go to either one of those. Right now it's on bonaventurelaw.com, and I'll probably post it to the other one. Email me it. I'll be glad to send it. Call, ask questions. There's both of my email addresses. Be happy to help.
Thank you so much. And I will see you all shortly who will be joining us for education law.